May it please the court. My name is Marie Borland from the Hillward Henderson Law Firm. I'm here today with my law partner, Rob Kelly. We represent the appellants Lowry and Jennifer Baldwin, and I'd like to reserve 5 minutes for rebuttal.
As you discuss your case, would you keep in mind some confusion I'm having? I am troubled by what I see as a conflating of Article 7 and Article 10 on the homestead exemptions for tax and the exemption from forced sale.
Right, Your Honor, and I know that's a part of this case because I think the trial court made that a part of the order, saying that he was reluctant to apply some of the Article 10 cases because of the two. And, you know, in examining this and coming to the conclusion that it doesn't matter, we really would ask your court to review the Kelly versus Spain decision. If you think about it, you know, in Florida, as a matter of public policy, the homestead exemption is to preserve the family home. So what difference does it make in the end whether you apply it in the Article 10 context or the Article 7? A homestead exemption is a homestead exemption for whatever purpose. But you don't have to take my word for that because that was part of the Kelly decision. And it said, the court talked about homestead has been given meaning in 3 different contexts. This is Kelly at 160 Southern 3rd, 81 and 82. Taxation, exemption from forced sale, and devise and dissent. But the court goes on to say, no matter the form, the goal of homestead has remained stable to protect the family. So we know...
That's a forced sale context.
That's an Article 7 case. That's an Article 7 case. And in that case, it was a case where a widow was continuing to claim an exemption after her husband had died. And sometime later, the property appraiser realized the husband had died and sought to impose a back lien because she hadn't filed for her own exemption. And it was sort of, you know, the same type of, with all due respect, gotcha tactic that we think was applied here. And the 4th District, in no uncertain terms, said, you know, this is not appropriate. The public policy of this state is to protect the homestead, and it wasn't fair to this widow to kind of apply this. It wasn't even a rule. I mean, she didn't need to do that. And so the court said very clearly, it doesn't matter whether it's Article 7 or Article 10, it's homestead. And the public policy of this state is to protect the homestead and those who are entitled to claim the homestead. So I'm glad Your Honor asked that question because...
Well, if they sold Whiteacre and pocketed $100,000, clearly that $100,000 is not subject to a claim by a creditor if their intent is to buy Blackacre, correct?
Correct.
But does that necessarily dictate that when I sell Whiteacre, I have to have something which is my residence before I get the tax exemption?
Well, Your Honor, let me put it this way in the context of this case. First of all, every citizen in Florida is entitled to claim a homestead exemption on a permanent residence. The issue of law before the court is how are we going to define the permanent residence? Is it a completed structure? No. Is it physical occupancy? No. It's intent. It's intent for the property to constitute one's permanent residence.
But doesn't that just completely undercut the date aspect of this? Then what's the whole point of it being January 1st of that year being at play here? What's the intent then if it doesn't matter when? So under the argument then, December 31st at 11:59 p.m. is when the certificate of occupancy is issued and they move in. You're saying the argument in fact says doesn't matter because they intended to.
Your Honor, we're not saying it was merely intent. You can't just sit back and say at some point I want this property somewhere to constitute.
But what you're asking the court, as I understand the brief, to say, and you've said it just now, that physical occupancy of a permanent residence is not to be considered.
The trial court, in a lengthy order, came to the conclusion that physical occupancy is not required.
Was part of the analysis.
The trial court came to that conclusion. We know that the legislature took out the language "and resides thereon." The Constitution provides every resident of Florida the opportunity for a homestead exemption for establishing a permanent residence. So if we can look at it, this is in the context of this case, in the context of public policy, we're not asking this court to depart from Florida law. There is Florida law on the books that governs this situation that we're asking the court to apply.
What's the point of the, 2 years to maintain Save Our Homes?
Well, the 2 years, I have no idea why,
We
the
have to assume, though, that the legislature understands the interplay between statutes. Wouldn't it render the 2 years meaningless as well?
not under these facts, not
Well,
whatsoever.
it would be 3 years under these facts.
If I may, Your Honor, let's
Sure.
just say the Baldwins sell their 3605 Beach Drive property and they decide to move to Switzerland for 5 years. They're probably not going to get a homestead exemption when they come back. They're beyond the 2-year period. But let's look at what happened here. They sell 3605. They abandon that homestead. They purchase 3601, and they immediately begin to prepare the property for that to be their permanent residence.
Repair?
They prepare the property. That's the language in the case law, Your Honor, and that's the test. It's called in the CJS treatise, and it cites to Florida law, the doctrine of constructive occupancy. That is the law in Florida. To be entitled to a homestead exemption, you have to, and the Kelly case says this as well. Let's start with Kelly because it's Chapter 7. That the owner has made or intends to make the real property his or her permanent residence. So we go on to Smith versus Hamilton, which, yes, is not an Article 7 case, but I think you have to apply. It applies.
That was a forced sale case.
It was, but Your Honor, again, if you look deeply into this, why should it matter? If the Baldwins had a judgment against them, I'm fairly certain no creditor would be able to come after the 3601 property. So why should it?
That's clear on the forced sale case.
But why should it matter? If the public policy is to protect the homestead character of property, why does it matter? And we don't have to make that determination today because the 4th District in Kelly has already said it. It doesn't matter. The public policy is to protect the homestead. So then we go on to the Smith versus Hamilton case that says, property may achieve homestead status sufficient to avoid a conveyance if the owner intends to occupy the premises as a home and perform specific acts to prepare the property for that intended use. It cites to the Florida Supreme Court's decision in Semple, and then the CJS treatise we've cited in our brief cites to Smith versus Hamilton. It says, under the doctrine of constructive occupancy, a homestead right may be impressed on property prior to actual occupancy if there is a bona fide and clearly defined intention to occupy the premises at some future time as a homestead, accompanied or evidenced by overt preparatory acts in connection with the property definitely tending to show such an intention. And they cite to Smith versus Hamilton for that proposition.
If your client sold one parcel, and for whatever reason, by the time to knock down the other one, to get the permits, yada yada, it's going to take 5 years to build a new residence. Is that property going to be entitled to the tax exemption?
Your Honor, I don't know. I don't know if I can't tell you. Okay. I can tell you, though, that in this case, on January 1 of 2015, there was a structure in construction well underway. The Baldwins had left their prior homestead. They had abandoned a homestead. They have had a homestead in Hillsborough County for 30 years. They're following the intent. I mean, they're trying to preserve the family home. They, in good faith, buy this new property. They enter into a contract for the construction to be completed in December of 2014. Is it really the public policy of this state to impose these sort of gotcha tactics? This is a harder test. The property appraisers and the trial court's proposed test is much more unwieldy, and it goes against the Florida Constitution. It goes against the Kelly case. It goes against the Smith case, the Semple case. It goes against the statute, because here we know that the purpose of the homestead has been preserved by what has happened in the facts of this case. The Baldwins are not trying to pull a fast one on anyone. They didn't buy another property in Florida. They didn't buy a property out of state and pretend like they lived out of state and try to claim 2 homesteads. They are in good faith switching their homestead from one parcel of land to another. Should
I
it-
have a question before we get too far, because you mentioned the simple case, and I want to kind of stick with that thread. The text of the Homestead Exemption, Article 7, Section 6 says you have to have equitable title or legal title and maintain thereon the permanent residence of the owner, which I conclude doesn't mean occupancy. But my concern is it says maintain the permanent residence, which seems to suggest implicitly that there is one there. And here we have no residence there. We have empty land that they hope to construct on, and they intend to get there some date unknown in the future. If it's a correct reading of the constitutional amendment that you maintain, or the constitutional provision that you maintain a residence, that must mean that the residence exists, doesn't it?
I don't think so, Your Honor. If that were the case, then wouldn't the court have said that you maintain that there is a structure on the property?
Have they been asked to say that yet?
Maintain a permanent residence, Your Honor, I would disagree, does not
Well,
mean the
there is at
maintenance
least
of a physical...
one court, a bankruptcy court, who looked at simple, and it says the simple passage refers to occupying premises, a term that connotates an existing structure and requires a manifest intention to occupy the premise immediately, not after construction of a house is completed.
Your Honor, I'm sorry, where were you reading from?
There's a case called Clements versus Farhood,
Mm-hmm.
and again, it's a bankruptcy court, so there's a question about homestead and collection of a debt, but they were talking about their interpretation of the simple case, which is one of those that you cited. They went on to say the case being cited from time to time simple, but never for the proposition that a lot without a livable residence can be a homestead if only the owner intends to build a house and live there at some point in the future. And my concern, if that interpretation by the bankruptcy court is a correct interpretation, then that means the language of the amendment says must maintain, there must be a pre-existing structure there. And therefore, if there's not a pre-existing structure there that you can intend to occupy, then that would go against your client's argument. And I'm not saying I advocate or agree with it, but I'm concerned as we're going through simple, and it's SEMPLE, right?
Correct.
Why is that analysis wrong?
Your Honor, I guess I would ask the court to let's look at the big picture. We're in the appellate context on a de novo review. Our argument is really dependent on the court going to public policy, and again, to agree with us that homestead is homestead for whatever purpose. The homestead, the public policy of the state is to protect the homestead. So if we start, that's step one. We already know that the Baldwins have in their favor the public policy of the state. Well, let's look at number two. What is the point of all of this? What is the point of of having these requirements? It's to say that, yes, you're entitled to a homestead exemption, but you're only entitled to one. And so the test then becomes, are you claiming more than one? We know that everybody's entitled to protect their homestead. Why are the Baldwins, shouldn't we be asking the question, why did the Baldwins lose their homestead? Were they trying to buck the system? No.
This case,
Excuse me.
I'm sharing your frustration, and I'm sharing the Baldwin's frustration here. The most difficult thing I'm having is buying the first step of the analysis, that we go right to the policy as opposed to what the will of the people passed in the amendment by saying maintain. I mean, to maintain is to maintain the existing structure. There wasn't any. I know that's hyper-technical, but this sounds an awful lot like the people have spoken, and what is our role here? This is a very difficult case for judges to decide, because I agree with you. It doesn't make sense if that's what the public policy is, but we have to look at the language that the people passed, both by the amendment of the Constitution as well as the statutes at play here.
Your Honor, I understand what you're saying. I disagree, though, with that interpretation of the language. Maintain thereon a permanent residence. I don't believe that means you have to maintain a structure. If that were the case, why would the Florida legislature have actually taken the words out "and resides thereon"? They're saying not only do you not have to have a permanent, you don't even have to live there.
Yeah, but you have to have somebody in your family living there.
Well, that's under the right on the Garcia case. But again,
No,
if
but
that
the
were
policy you make, its argument is correct. It's illogical to say that you have to buy an existing structure, because that is like almost an economic decision the book of economics, I forget what Holmes said about economics, but you can't buy land to build your dream house on because there's not existing.
Right,
Yeah,
and,
the policy, that argument, and I share Judge Belling's concern. My concern is, what did the voters actually approve, and what does it actually mean?
so, Your Honor, if...
Does it maintain a dream, or does it maintain a structure? I prefer the former, but they may have written something differently.
Well, if we can flip-flop this, then what public policy is served by depriving the Baldwins or homestead exemption? And that's where you find the intent. What is the intent of this? The intent is for every family in the state of Florida to be entitled to one homestead exemption.
See, if we do it by intent, we run into the question that Judge Larez asked. At what time do we subjectively say as a court of law that your intent is no longer the dispositive determining point, whereas the language policy says, don't have to worry about that, we have an objective standard. You maintain a structure as your residence, so something that exists, you have the benefit. And one of the benefits of that is it takes us out of the business of having to make subjective determinations about the credibility of witnesses on appeal or the trial court or whatever. You either did or you didn't. It's a pretty bright line rule.
But, Your Honor, where is it said that there needs to be a structure? Where is it said in Florida law that there needs to be a structure?
Only about maintain, and if you draw, that means there's an existing structure.
That is an interpretation of the word maintain. But
That-
maintain,
that's the
it doesn't say
argument, right?
maintain a structure.
That's the argument, isn't it? That it maintains, we're interpreting, and that there's an inference to be drawn from that.
How does that further the public policy of the state or the framers of the Constitution to interpret the word maintain that way? I would submit, Your Honor, it does not.
On December 31st of 2014, would you say that there's a factual dispute here that the Baldwins intended to maintain their residence the next day on January 1st, 2015? Now, at this point, there has not been a certificate of occupancy granted here. The house was not moved into at this point. Would you say on December 31st, the next morning, on January 1st, 2015, that the Baldwins intended to be there and live on that property on January 1st, 2015, which that date has been given inclusion, and we thus must give it meaning by the legislature?
I would not only say that there is not an issue of fact with regard to their intent on December 31, I'd say there wasn't one back in July of 2013. It was always their intent to maintain their permanent residence on that piece of property. They abandoned their former homestead.
What is the meaning? Why is January 1st included?
Why is, on the lien date? I don't know the purpose of the two-year rule.
Do we have to give it meaning? Or you're saying that we need to interpret the Constitution's word maintain differently. We need to read out the legislature saying January 1st, and we have to excise that out. Is that the role of the courts to do this, to discern, to get to the intent for, as you put it, step first of the analysis?
Your Honor, we're not asking the court to excise out the word maintain or the January 1 lien date. We're not asking for that at all. We're asking the court to go back to the beginning to see what was the purpose, what are the purpose of the homestead laws. Was that purpose subverted in this case?
So why not 5 years, 10 years, 15 years? I got a really slow one-armed builder.
Listen, if I may, just explain why in the context of this case that's not a concern. Now, our argument is dependent on the court agreeing with us that for purposes of this analysis, it doesn't matter whether it's Article 7 or Article 10. We know that from the Kelly case, so we have some authority for that proposition. What do Simple and Smith stand for in the doctrine of constructive occupancy if we are not going to apply them in this case? It's not just intent, it's intent accompanied by overt acts to prepare the property. On the January 1 lien date, they met all the hurdles. No one can deny that they were actively preparing that property for permanent residence on January 1. Now, again, I mentioned if they were living in Switzerland and there was a piece of vacant land and they weren't going to come back for 10 years and maybe they had a beach house somewhere else that they were claiming, well, certainly not. But that's not our facts. Our facts
What's the
are-
holding in this case? I'm going to write an opinion in favor of the Baldwins. I'm going to write the holding of that case. Tell me the holding.
Okay, well, Your Honor, I thought about that, and I actually wrote in the margin of my notes, what would the opinion say?
Tell me what the opinion says.
The opinion would talk about the public policy of the state of Florida in terms of homestead exemptions is to preserve the family home. It would cite to the Kelly case for the proposition that it doesn't matter which of the three versions, they all apply equally to protect the family home.
So we can blame Judge Gross, huh?
The court is at it, can do whatever the court wishes to
I'm
do.
sure he'll thank me.
When I wrote the words opinion, I also put an arrow the way to Florida law. The court would then talk about 196031, how the legislature had excised out the residency requirement. The court could then talk about the Smith versus Hamilton and simple analysis, talking about maintaining the family residences also includes preparation, overt acts to prepare the property for that intended purpose. I wrote down then the court, again, would conclude with Florida public policy that the trial court's holding is contrary to the Constitution, it's contrary to case law in this state, Kelly, Semple, Smith, and it's contrary to Florida public policy.
Okay, Ms. Borland, you were 21 minutes. You've been peppered with a lot of questions.
Okay.
But we'll save you some rebuttal time, okay?
Thank you, I appreciate that.
Thank you.
May it please the court, Will Shepard, General Counsel for the Hillsborough County Property Appraiser's Office. The trial court's decision as to the homestead itself was based on undisputed facts, but based on a lot of them, which the court had to weigh. So we find that the standard here is clearly erroneous. The court looked at those undisputed facts, weighed all those, found that the homestead was not deserved. The burden of proof is on the homeowner, and the statutes are to be strictly construed against exemptions. So the property appraiser, the value adjustment board, and the court all found that homestead was not entitled for that year. The Baldwins, of course, got homestead the subsequent year. But as of that year, it was determined that did not have homestead. The trial court.
What's the test?
I'm sorry?
What's the test to determine whether you're entitled to the exemption?
I think the test is physical occupancy combined with, or establishing physical occupancy and then combined with some sort of intent. So in other words, once you're in the door, you can certainly leave, and we have instances where somebody gets transferred to New York on business, or they're ill and they go somewhere else and they stay somewhere else. In all those scenarios where they've established the residency, we certainly look at intent. The property appraiser is not suggesting that intent is not.
In those hypos, the intent is always to return.
That's correct. That's correct.
Is there a question of intent here?
No, I don't think there is a question of intent. I think there was an intent that this will be our homestead, that we desire this to be our homestead, that we want to establish a permanent residence there, but we cannot. At this point, they did not do that. As of January 1 of the year in question, they did not do that.
Well, they cite to Kelly, and in Kelly, Judge Gross, writing for the majority of his panel, all three, says there's three factors for homestead exemption. And that, I think the one that issues here is two, that the owner has made or intends to make the real property his or her permanent residence or that of his family. It doesn't say make the structure their home, it says to make the real property their home. Now that comes from probably the jurisprudence of the state. If the language that we are to look at is real property as compared to maintain the residence, that may change the analysis.
Well, all right, let me hurt my own argument here for a minute. I'm not sure that the court is correct when it uses the term permanent residence as a physical structure. I think residence means the place where they reside. But I will say this, the property appraiser would grant homestead to somebody living in a tree on a vacant piece of property if that's where they actually lived. If every night they went home and they climbed up in the tree and lived there, we would grant them homestead.
So Mrs. Baldwin should have spent more than one weekend in a tent on the property.
Perhaps so. The court described it as camping, not residing.
Right, it was a camp out.
That's correct. It was an act of desperation, I think.
They would would have gotten the exemption.
We had, I think the trial court referred to tent man. We actually had a gentleman who lived in this completely dilapidated house. It was a kid out of college, bought it sight unseen, and we denied it. We said, he's not living there, he can't be living there. Well, he proved us otherwise. He was living there every single day. We granted him homestead. The problem with the Kelly...
It focuses on what is your permanent residence. And so if it's a tree, it's a tree. If it's a tent, it's a tent. If it's just standing there facing the elements, it's the real property.
That's correct. That's correct. The problem with Kelly versus Spain is this. First of all, the court, it's dicta in the court there. The court wasn't agonizing over homestead. They were agonizing over whether the wife could receive the homestead without having filed an application when the husband passed away. It was his homestead originally. So the court's language there is dicta. But more importantly, as you pointed out, the court points out 3 criteria. One of them is a size criteria. That size criteria is nowhere in Article 7. The property appraiser is going to grant you a homestead whether you have 100 acres. That doesn't matter. That is
That's
a different...
protection against a creditor.
That's correct. That is a different constitutional test. Moreover, it's different. So, you know, we're very fond of calling homestead the legal chameleon, but the reality is they're different animals. Okay? Maybe they're from the same tree, but they're different animals. You have different constitutional provisions. You have the size requirement in that. That's not in Article 7.
But if the trial court here had determined that the the act of staying on the, let's go ahead and unpack this, if I remember it correctly. The act of staying on the land in the tent for the weekend, if I do recall correctly, driver's licenses were based on that property. There was other attachments to that property. Had the trial court made a factual determination that that was their residence, okay, what would the argument be for the property appraiser on appeal? So it's a factual determination that it's their residence, where here we had a factual determination that they camped out. I'm trying to understand the analysis here.
I'm not sure.
Would you be able to say that that was a clearly erroneous interpretation of what residence is based on?
I'd make that argument. I'd make that argument that, yeah, based on the facts here, the court can't come to the conclusion.
So
But
the argument then is, from the top-down approach, the will of the people is the Constitution. The Constitution includes the word residence. The then, as directly voted on by the people, and then through the people's representatives, the legislators then included residence in on Chapter 196. It's to convey the concept of a structure. Then, what's it to convey?
I think the word permanent residence conveys that that is where they reside, whether it's what sort of a structure it is. The property appraiser, in my 20 years, were not concerned with. But what Article 7 says is...
Permanent residence within the meaning of the Constitution, would you say that's an ambiguous term?
I would say it is an ambiguous...
So then we would apply the standard that Judge Gross articulated in his opinion, that we must endeavor to construe the constitutional provision in a manner consistent with the intent of the framers and the voters, right? Does that then allow a consideration of public policy?
I don't think it does. I think it's spelled out pretty well. Although permanent residence, we have to look in the whole framework here. It says legal or equitable title in Article 7, Section 6, to real estate and maintains thereon. Maintains does not mean intends to maintain. It means
maintain real property.
existing.
Maintaining a permanent residence, that would be arguably the constitutional term of art, permanent residence. And so the question is that phrase ambiguous or clear? If it's ambiguous, then as Judge Gross's panel pointed out, there's an interpretive way to do it. And if it's not ambiguous, in the sentences before that, he says this is what you have to do, which is a consistent line of reasoning in all the districts. Not to pick on Judge Gross, who I like a great deal.
Well, we have a statute that further helps us define permanent residence. We have 196.01217, definition of permanent residence. That place where a person has his or her true, fixed, and permanent home and principal establishment to which, whenever absent, he or she has the intention of returning. When the homeowners camped out on the tent, they went back to the condo.
Well,
But they had the intent to return, though, once it was completed.
I don't think that truly establishes. I think
What else does it establish if that's where their addresses are, and they've maintained 30 years of homestead in this county, where else were they gonna go?
Well, homestead goes from one home to the other. It's a different homestead each time you get it. Now, let me say this, that
But it bootstraps the Save Our Homes, though, and that's all I'm getting at with that point. So you're saying the record would not support that they intended to return?
that's correct, and I have to point out here, the court doesn't have the full record. The court doesn't have the depositions of the homeowners, the deposition of Marilyn Martinez. What the court found was the driver's license, the voter's registration, and living in the tent. Those were all acts to attempt to get homestead, not really to say, this is really where I live. This is, oh my gosh, we're running out of time. We're at the last minute here. I got one more day. I've got to somehow convince the property appraiser that this is where I think I'm living, and so I'm going to get these documents. I'm going to pitch the tent. But the court doesn't have, that was in the record that the court doesn't have.
Just a moment ago to one of your arguments.
Yes.
Where you invited us to take a look at Chapter 196. My concern is this, to paraphrase Chief Justice John Marshall, it is after all a constitution we are expounding, which is part of the judicial function. So does it matter how the legislature defines the terms in the Constitution? Isn't that for the judicial branch to do, to decide what those terms mean?
I think that once the well, yes, you're right. There is.
They can implement that, but ultimately we,
As
that's
a-
my concern, You invite us to go down that path, and it may be a nice path, but I don't know that we can abdicate our responsibility. And that was the point of the question. If it's up to the court system, the judiciary, to interpret the provision of the Constitution.
Well, the property appraiser is certainly going to follow the statute until that time.
Yes, sir.
Again, there's strict construction of the property tax homestead, whereas there's liberal construction of the forced sale. So you have different constitutional provisions. You have different statutory provisions. You have the strict construction. You also have multiple cases, Grisolia and multiple cases, already identifying that these are really different concepts and we should not allow them to bleed over. Again, we're not saying that intent has no place, but we're saying it must be combined with actual occupancy. And ironically, that is one of some of the homestead cases say in the non-property tax convention, that they say that the test is intention combined with actual occupancy. That's even outside the property tax. And you see a scheme in the property tax world. Permanent residents, you have the rental statute where it says if they rent it, they don't get homestead until it's physically reoccupied. There's this whole sense in the property tax world that the physical occupancy is an important aspect of that. The Semple case, I simply think it's too old. It's 1921. We got different constitutional provisions. The Constitution was changed in 1968. Even in Semple, when you look at the court's decision, they said, quote, the property not being in actual use and occupancy by Semple and his family, and not being in condition for occupancy for 2 months after the execution of the deed. Those are specific issues even Semple identified. So really in none of these cases where there was no occupancy did the court actually find homestead, even in the non-homestead, even in the non-property tax cases. When you read through all the facts in those, and in all those cases, did the court conclude to homestead without actual occupancy. Talk a little bit about the notice provision. 196, 193, I believe, is general denials except for where some other statute exists. And the reality is nowhere does 193, 196, 150, 193 reference homestead. There's no appellate decision that's ever applied 196, 193 to homestead. There's a reference to person in that statute. The Department of Revenue raised that issue. Well, it says person in there. Because there are other exemptions, non-homestead, that a person, an individual, can get. The economic exemption, the historic exemption, the renewable energy exemption, those are all exemptions that can be received by an individual. And those exemptions don't have their own specific statutory provision for how you do the notice of the denial notice. Also, individuals can and do apply for nonprofit exemptions. We have a guy who every year applies for a religious exemption on his home. He can't get it, well, we have to send him a denial notice. So this statute, I think, covers that. Subsection 5B, the legislature's intent is absolutely clear. I mean, they spell it out in the bill summary. They say this is about nonprofits and the detail you have to provide a nonprofit. It's different criteria. 196-151 specifically identifies homestead. It only identifies homestead. And there's different criteria. You only have to state the reasons. You don't have to get into this great detail that you do with the nonprofits. It's personal delivery or regular mail or registered mail. That's different. There's no appellate decision that has discussed 196-151 in any other context than homestead. So we really think that is the specific statute. That specifically addresses homestead. That's different than the sort of general homestead. There's a reason. Keep in mind that 5B, 196-193 5B, was added in 2007. When they added that language of 2007-106, they put it in 196, not 193. They did not put it in 196-151, which addresses homestead. That's not where the legislature chose to put that language. They chose to put it in the more general statute, 196-193, the non-homestead statute, with regard to denial notices. Even if 196-193 applies, the statutory criteria was met. The property appraiser identifies the statutory violation, what statutes it didn't comply with, and the property appraiser says it wasn't at their permanent residence. They weren't living there. It's not where they resided. So we think it covers really all of the facts anyways. We have a concern with being able to grant a homestead based on a denial notice. If somebody has dual homesteads, they have homesteads in two different places, and they're living in France for 5 years, the fact that the property appraiser misses something on a denial notice, all of a sudden they get homestead, contrary to all the constitutional provisions, all the other statutory provisions, that seems a stretch. I'm general counsel for the property appraiser. We deal with these things all the time. I will tell you that we have more and more and more and more homestead cases all the time, primarily because of the Save Our Homes. These are issues that the property appraisers, I can tell you, I'm doing a conference tomorrow with all 67 of them, that they're looking for some guidance on here. I look at the big picture. I mean, a PCA, wonderful for me, but with regard to trying to help property appraisers out here, some guidance would be helpful. We simply think these non-homestead cases that talk about intent, they're not applicable in this case. Multiple courts have said that. We would like that reinforced, that this is a different criteria, it's different statutes, it's a different analysis. They should not be blended. And that 196, 193 does not apply to homestead exemptions. That has their own separate statutory provision.
To what extent does the lack of the complete record and depositions play into your invitation for guidance? Yes. I mean, I'm sort of biting myself here with regard to that, because yes, the record's incomplete, and the court, it's a clearly erroneous statute. And I do appreciate that. I always look at these cases from the big picture, because this is my client. It's where I'm at every day, and I deal with it every day. So, yes, that's a consideration as well, and I acknowledge that.
Thank you, Mr. Shepard.
Thank you.
Ms. Borland?
May it please the court. This is a de novo standard review. It is not a clearly erroneous standard. And in terms of the record...
It is as to the facts, is that correct?
I'm sorry, Your Honor?
It is as to the facts, is that correct?
There are no facts in dispute.
There are undisputed facts.
There are undisputed facts, and the issue is one of
Understood,
law.
thank you.
Right. And in terms of the record, we have the summary judgment hearing transcript and the BAB hearing transcript, so the depositions don't add anything more. So I would just say that we have a complete record. But more important, I would say with all due respect, the property appraiser has sort of proved our case, because the court seemed very concerned about the fact that, there was no completed structure. Well, the property appraiser has now conceded that if someone is living on a tree in a piece of property, that the property appraiser will give them a homestead exemption. So then it becomes, it's what he is saying, what the property appraiser is saying is the issue now for the property appraiser is residency. Are you living on the land? It has nothing to do with the structure. So is this the public policy of the state, to have Florida residents pitching tents and living in trees? I don't think so. I think we do need guidance, and I think we need more guidance now that we have received this concession. And what should the test be? Well, again, I would implore the court to look at the overall purpose of the homestead and the Save Our Homes Amendment. Let's consider what this means. Save our homes. How is Baldwin's home saved by this set of circumstances? When it's undisputed that it was always their intent from the moment they purchased this piece of land and abandoned their other homestead to establish and maintain thereon their permanent residence, and they were performing acts up until on January 1 to prepare the property for that intended use. What would the opinion say? The opinion would be quite straightforward. What did the Florida Constitution says? It took out the "and resides thereon" language. It took that language out. The framers did. So we know that residency, as the property appraiser has said, is not a requirement. We have the Kelly three-point test. It is not dicta. It went straight to the issue of the widow's entitlement, in that case, to the homestead exemption. It said you intend to make the property your residence. That is what you need to show for a homestead exemption. Is this an issue of public policy for this court? Yes, it is, to define permanent residence. And I would say, again, given the test advocated by both sides, it is very important for this court to set forth some guidance. I think it's very unworkable for the property appraiser it's sort of the smoke and mirrors. What is it? Is it a physical structure? That's what it seemed to be from the trial court's order. Is it living in a tree? Or is it, let's apply the public policy of the state and what the framers of the Constitution intended? It's to save the home. The Baldwins have lost their Save Our Homes benefit because of the happenstance of a delay in construction, but that's not the test. The test is, was it their intent to maintain their permanent residence on this property? Absolutely. And that's exactly what they've done. And we know that. We know they moved in. So it was their permanent residence, and they're not trying to buck the system. So we are asking the court for guidance. We're asking the court to reverse the trial court summary judgment order and reinstate the Baldwin's homestead exemption and Save Our Homes benefit for tax year 2015. Thank you.
Thank you very much.